hello to everyone out there for joining us. Sorry for the slight delay to deal with technical issues. Hopefully everyone out there can hear us. This is Maria Panichelli, and you are joining us for a webinar on critical concepts in federal subcontracting. This is part 3 of a 4-part series that we are doing that concentrates on government contracting, the GovCon webinar series. And my firm, Obermeyer, is presenting this in conjunction with the University of Hartford and the Women's Business Center there. So before we get started and dive into the content, I wanted to just introduce myself and let you know a little bit about me and my background on these topics. My name is Maria Panichelli. I'm a partner and the chair of the Government Contracts Practice Group at the law firm of Obermeyer, Redmond, Maxwell, Hippel, LLP. You can see my contact information here up on the screen. You'll see that the last screen as well. But feel free to, during the presentation, ask questions in the chat box. But for those questions that we're not able to get to during the presentation today, please feel free to reach out to me, phone, email. And you can also see my Twitter and my LinkedIn where I share other presentations such as this one that I will be doing, as well as blog posts and other news stories and legal developments relating to government contracting and small business procurement. As a partner and the chair of the Government Contracts Practice Group, I focus my practice exclusively on federal government contracting. So I help government contractors, both prime and sub, across the nation and abroad, that do business with a variety of federal agencies. We help them through every stage of the procurement process, from the pre-award, interpretation of solicitation stage, through any bid protests, through performance and compliance counseling, and through any dispute resolution that arises either vis-a-vis the government or vis-a-vis, or I should say between subcontractors and primes. And then a big piece of our practice is also small business procurement. What we're going to be focusing on today is the subcontracting piece. The unique world of federal government contracting kind of poses special issues and challenges that make the subcontracting relationships a little bit unique. So today we're going to be talking about some key concepts in federal subcontracting, which is a big part of my practice as well. So in today's agenda, what we're going to be doing is starting with kind of a primer, talking about the proper approach to take when you're thinking about subcontracting relationships on federal projects. We're going to then move on to talk about flowdown clauses, moving from there briefly through subcontracting limitations, on to pass-through claims, and then finally claims between primes and subs. So, like I said, we're going to start with a little bit of a primer, and this is more of a, I guess, an attitude-based thing than a legal-based thing. But what I see is, what works best in any context is, trying to work together and not coming at things from an adversarial point of view. Now, obviously, when you're negotiating a subcontract, the subcontractor is going to have certain interests. The prime contractor is going to have other interests, and sometimes they might come into conflict. But what you need to remember in the federal government context is there's always the federal government kind of like they're the elephant in the room. And what you need to do is find a way for the prime and the sub to work together in such a way that works for both of those parties, but also that works for the federal government and protects both of those parties against anything that can go wrong with the federal government. So the overall continuing theme here should be cooperation, integrity of both parties and a willingness to work, an ownership of the issues and an actual proactive desire to get things done, and obviously cooperative spirit where you're willing to work together and compromise. Honesty, transparency, and open communication kind of all go together. The importance being, you can't work together if you're not really understanding where the other side is coming from, and if you're not being open and honest and transparent with each other. The other thing that's important to keep in mind is kind of empathy and understanding. And I know this is going to sound very, new agey for a legal webinar, and don't worry, we'll get into the nitty-gritty, nasty lawyer stuff later. But one of the things that's really important when dealing with subcontracting in a federal context is to realize, there's no point in negotiating to negotiate, right? Negotiation is in order to try to get somewhere and reach an agreement. When you are dealing with the federal government as the owner or the final customer or client, that's going to mean that the prime contractor has a lot less wiggle room, a lot less flexibility, et cetera. So you need to have a system worked out where the subcontractor understands that, yes, you can push back on certain issues, but on certain issues, the prime's got nowhere to go. They've got to answer to the federal government, and they've got certain obligations they have to meet, and you're not going to get anywhere trying to negotiate those clauses. So a lot of what we're going to be talking about today, we're going to talk about things from a prime point of view and from a subcontractor point of view, but you might feel as though there's a little bit more focus on a prime's point of view. The reason for that being, they're kind of the link in the chain, right? They're the party that separates the ultimate user from the subcontractor. And everything that they're going through with the federal government and all the obligations that the federal government is putting on them is going to impact how they're able to negotiate or how much they're willing to negotiate with the sub. So even when we're talking about something from the prime contractor's point of view, you've got to keep this empathy and understanding piece in mind, because it's useful for subcontractors to understand from a prime contractor's point of view where the prime is coming from as well. That's going to inform the subcontractor's understanding of where they may have wiggle room to negotiate and where there's just no chance and they're not going to be able to move the prime contractor off of the position that they've taken. So with that in mind, kind of that overall mental framework, or that approach to the information we're going to be covering today, we're going to move on to the first kind of substantive chunk and talk about slowdown clauses and risk shifting provisions. So what are flowdown clauses? Because that's kind of a weird term that you don't necessarily hear in everyday parlance. Flowdown clauses, or sometimes called flow through or pass down clauses, but most frequently flow down, are FAR clauses that are included in a contractor's prime contract with the government, where the prime contractor is required or may choose to flow it down to their subcontractors. In other words, they take it from their upstream contract with the government, pick it up, copy it, move it into the subcontract. That is, in the strictest sense, what a definition of a quote-unquote flow-down clause is. However, sometimes you will hear the term used as kind of a more broadly encompassing term that kind of refers to not only the clauses that you actually have to cut and paste and modify, but just kind of conceptually the idea that, there are certain things you need to do as the prime contractor to make the government happy. How do you flow down those obligations? Maybe it's not as simple as cutting and pasting a specific clause, but what concepts do you need to account for? What risks do you have vis-a-vis the federal government where you can try to shift some of that risk downstream to your subcontractor? So sometimes when you hear the term flow-down clauses, or when people are kind of using that terminology, it encompasses not only strict quote-unquote flow-down clauses, those clauses that you're either required or you might want to cut and paste from the prime contract and put into your subcontract, but also other risk-shifting provisions, other concepts that you flow through to make sure that the obligations between the sub and the prime are the same as the obligations between the prime and the government. So why is this important? And I've kind of alluded to this previously as we were going through the introduction, but federal contracting is a unique space. It's different than normal commercial contracts. It's different than, other private contracts that you might have, other local, state entities, etc. And actually, I'm hearing a little bit of background noise, so for those of you who are signed on, if you could go ahead and mute your lines, that would be wonderful. Thank you. So in addition, they're ruled by a different set of laws. Usually when you're dealing with private contracts or, contracts between two private actors, you're dealing with, contracts that are ruled by whatever state law those contractors choose to put in their contracts. When you're dealing with federal contracts, you've got the FAR, which is the Federal Acquisition Regulation, along with any agency supplemental regs, and possibly if you're dealing with set-aside contracts, small business regulations, small business concerns about eligibility, teaming, one of the things we're going to talk about later is subcontracting limitations, etc. In addition, they're subject to a completely different set of dispute resolution procedures. Again, if you're used to dealing with, regular general subcontracts where you go and you sue them in state court for breach of contract, that's not how it works in the federal government sphere. Depending on how the claim is being adjudicated and who it's against, you might very well end up before a specialized court. And we're going to talk about that later when we get into pass-through claims and claims against between primes and subs. But you're going to end up before the contracting boards of appeal, or you're going to end up before the Court of Federal Claims. And you're going to be doing that in accordance with the FAR and the Contract Disputes Act as opposed to a general breach of contract legal theory. So what does that mean from a practical sense? It means that, flow downs, the idea of slowing things down, the idea that a general contractor or a prime contractor would try to account for certain issues in their upstream contract in a subcontract, that is not unique to government contracting or to federal government contracting. You might have a situation where that happens in a private contract or in a state contract or in some other sort of contract that's not federal. But in those contexts, there might be a little more wiggle room in what needs to be flowed down or, what the ideas are, or what the conceptual, framework is. Federal government's going to be different. The reason for that is the government is the ultimate end user. The government does not bend or negotiate. FAR clauses are what they are. You're not going to get the government to back off of a FAR clause in a prime contract. Prime contractor is going to therefore have very little wiggle room. You might have certain demands or wants as a sub, but the prime contractor just got certain things they're going to be able to wiggle on because maybe they have some room to work with. But other things, nope, the federal government wants something from the prime, so the prime is going to need the same from you. Prime contractors can therefore be reluctant to negotiate with subs. And again, going back to the idea in the introduction of, empathy and understanding, you want to try to put yourself in the other party's shoes, not, for any new age kumbaya reason, but frankly, because it's going to make the negotiations go smoother and it's going to make the ultimate relationship be stronger and hopefully therefore lead to a more lucrative and successful performance of the contract experience. The prime's probably going to be thinking, look, I can't afford to be stuck in the middle. I can't afford a situation where the government wants me to do something or the government can assert damages against me and I don't have any recourse against my sub if the sub's the one that messed up. Or maybe it's a situation where something went wrong on the contract and my sub's coming after me and I'm trying to go after the government. Now I'm fighting a battle on two fronts. That's inherently not a good situation, to be in. It's also not a good situation to be in when your subcontractor puts you in a position that endangers, your relationship with the ultimate customer or end user, the federal agency. Meanwhile, subs might be thinking, especially if you're less familiar with the FAR or less sophisticated with government contracting concepts in general, hey, this is a new and complicated space. The industry is pretty unique. There seems to be a lot of niche, knowledge bases that I might know or I might not know, I need to protect myself and I need access to remedies. And we're going to talk about that a little bit more at the end of the presentation. But again, important to understand where the other person is coming from so you can kind of define the boundaries of what you are willing to negotiate, what the other party is willing to negotiate, and what the deal breakers may or may not be. All right, so let's get into the substance of, all right, we talked about what flow-down clauses are, why they're important, what each party might be thinking. How do you figure out as a prime contractor what you're going to flow down? How do you know what needs to go in your subcontract? Well, like many things in law, that's going to depend. You're going to have three major categories that you're going to want to account for. Mandatory flow-down clauses, that's a no-brainer. Obviously, if it's mandatory, you're going to want to flow things down because you have to. There's also suggested clauses that are kind of a good idea to flow down. And then there are suggested considerations. And by that, I mean kind of going back to what I said about the distinction between strictly, quote-unquote, flow-down clauses and those risk-shifting provisions, other concepts that you want to think about and incorporate into your contract. So taking the first one first, mandatory flow-down clauses. How can you tell what is a mandatory flow-down clause? Well, pretty simple. The FAR is usually going to tell you. The FAR, the Federal Acquisition Regulation itself, will state whether a clause must be flowed down to a prime subcontractors. So that doesn't mean there's a list out there that you can go consult. It means that this might be a somewhat, labor-intensive process if you've got a new contract to go through, see what FAR clauses were included in your prime contract, either by reference or incorporated in full text, you know, you usually have both. There's usually a bunch of clauses incorporated in full text, and then on that list you get of FAR clauses that are incorporated by reference. And you're going to have to check and see which of those are mandatory to be slowed down and which are not. If they're mandatory, you obviously need to put them in your subcontract. Now, do not make the mistake that I have seen several contractors make, several of my clients make before they came to me, which is to confuse mandatory and automatic. The fact that something must be slowed down from a prime contract to a subcontract doesn't mean that, therefore, it automatically is slowed down. It's not, hey, look, these are all the clauses that automatically are going to be considered in your subcontract. Quite the contrary. The idea is that these are the clauses that you, as the prime contractor, have an affirmative contractual obligation to research, make sure they're mandatory, put them in your subcontract. So don't confuse mandatory, which imposes an affirmative obligation on you, with automatic, the idea that it's automatically taken care of without you having to do anything. One interesting twist on this is to keep in mind what version of the clause must be flowed down. And the idea, behind all these flow down clauses is to kind of make sure that the obligations that the sub has to the prime are the same as the obligations that the prime has to the government. Again, it's all about the prime contractor trying to make sure they are not caught in the middle where, something is expected of them upstream that they can't expect from their downstream. Or, that there's a problem that the subcontractor has that they can then flow through based on, claims procedure to the federal government and take that, up and pass through a claim. So the key here is consistency. You're going to want to make sure that the sub is obligated to the prime to the same extent the prime is obligated to the government. You're going to want to make sure that the obligations the, prime has to the sub are going to be covered by the obligations that the government has to the prime, et cetera. So if you think about that, this idea of, which form of the clause must be flowed down makes a little bit more sense, because the answer is you have to flow down the version that was in your own prime contract, even if there's a new version out there. Now, most of you would say that's completely counterintuitive. Obviously, bigger is always better. More recent is always better. The more recent version or the more updated version is what I should include. You should never use an old version of anything. And in most contexts, that's right. But remember, you're dealing with the federal government here, the unique world of government contracting. It's not always the common sense answer. Sometimes there's something that's a little bit counterintuitive. And when you think about it, because consistency is the goal, this does make sense. If you've got one version of the clause in your prime contract that says, hey, these are the obligations between the prime and the government, and the whole goal is consistency to make sure that the subcontractor, their obligations mirror the prime contractor obligations, you're going to want to flow down the old version because the old version is what would promote consistency, even though that's kind of a, counterintuitive thing for most people to kind of put their hands around. So other things to keep in mind: can you flow down an entire contract by simply incorporating it into the subcontract? Sometimes you'll see lazy drafting where someone tries to just put a clause in there that has everything. In other words, the prime contract is hereby flowed down. That's really not going to be effective. It's not efficient. It's not best practice. It can make subcontracts much more expensive. And you're also going to deal with things, for example, flowing down U.S. job site safety and security provisions to a foreign supplier isn't going to make any sense. The more specific you can be, the better. You should be flowing down the essential prime contract clauses, those mandatory clauses, and also you should be keeping in mind that in order for a flow down to be enforceable, it needs to be modified to fit the subcontract. You can't just be flowing something down kind of in total. What other clauses should be flowed down? Now, we've talked about mandatory flow down. What other things do you need to be thinking about and do you need to be trying to incorporate into your subcontract? Answering this question is not a quick one-word answer. It starts with really understanding why you're flowing things down or why you're including clauses in your subcontract. And again, remember that whole idea that you don't want to be caught fighting a battle on two fronts. You want consistency. So from the prime contractor's point of view, what is the purpose of these clauses? Now, obviously, the mandatory clauses, the purpose is that you need to be slowing them down. That's a mandatory obligation that the government has put on you. But with these other ones where they're just suggested or recommended, what is the purpose? Well, the purpose is, remember, the prime contractor is ultimately responsible for the completion of the contract, performance of the project. They are ultimately responsible for the performance of their subs, whether their subs are good and, do their job well and fulfill their obligations, or if they perform badly and there's deficient work or, errors or something that needs to be corrected or some sort of damages that are caused. The federal government is not messing around. They're not going to accept finger pointing. I have a lot of clients who think, hey, I'm the prime contractor, but it's not my fault. It was the sub. The sub's the one that messed up. And while that means that certainly you can deal with that vis-a-vis the sub and perhaps deal with it between, with a claim in between the prime and the sub, which we're going to talk about later, the federal government doesn't want to hear it. It's still your obligation as the prime to get this job done. If you hired a deficient sub and didn't supervise him properly, that's going to be considered to be on you, and that's going to be your problem. So when you're a prime, what you don't want is a subcontractor that performs badly, therefore, forces a default, causes a notice failure, causes a delay, causes any sort of problem where where the government's going to come back and blame you. You know that you need to be vigilant. So what do you need to think about then? You want to be vigilant. You want to avoid fighting a battle on both fronts. You want to make sure that you are having your sub be responsible and obligated to you to the same extent that you are to the federal government, so that you're not disappointing the federal government. Based on these concerns, you want to think about a couple things: protection against subcontractor-caused default situations, protection against notice failures, clauses about administration of the contract, and clauses about disputes. And we're going to talk about that last one in depth in just a bit. But really, you're going to say, all right, what do I want to do here? How do I want to protect myself? What are the things that could happen where a subcontractor could cause a problem that I would get in trouble for? How can I protect myself against that? What are the things that could happen where a subcontractor could cause a delay where the government then comes back and assesses liquidated damages against me? How can I protect myself against that? And that's going to be specific to your contract and your relationship and what risks you see and how risk-averse you are. But the other thing to think about, and that's kind of the substantive concerns that you want to be thinking about, but also just in terms of form and the way that you actually want to incorporate these into the contract. Do you want to flow down the language? Do you want to actually cut and paste a clause and just tweak certain words? Do you want to flow down a clause but kind of, not the whole clause and maybe not verbatim, maybe not word for word, but, the essence or the purpose? Or do you really just want to address the issue? It's not about cutting and pasting something from the prime contract. It's about just making sure that you've got a risk-shifting provision in there. And again, that's all going to depend on preferences, how risk-averse you are, and what the specific issues are that you think might come up with your subcontractor. So let's talk about some examples. We've been talking about kind of general concepts, but let's nail this down with some specifics so you can see how this comes into play and, how it can affect a prime contractor, how a prime contractor can get themselves in trouble. So in the example we're going to be using, we're talking about a termination for convenience. And for those of you who aren't aware, mostly all government contracts, if not all, have a termination for convenience clause, which allows the contracting officer, the government, to terminate a contract when it's in the government's best interest. Now, this is not the same as termination for default. It's not a black mark on the contractor's record. It's not an indication that they did anything wrong. It's just an end to the contract, and it's because the government has decided, hey, we no longer need whatever we hired you to do. This generally happens in situations where, for example, you'll see it happen if they're in a conflict area, the Army wants to build something in a conflict area, and then boundaries change, Army moves on, maybe they don't need a base in that area anymore. Or maybe there was, a bridge that was going to be built or a certain, information system that needed to be implemented, but now the government has changed their mind, or maybe they've figured out that it's going to be too expensive, more expensive than they thought it was going to be, and it's just not worth it, or they don't have the funding, and the contract it's in the best interest of the government to just terminate the contract. Contractors generally going to be entitled to the costs that they incurred, most likely the profit on that portion of the work, but not the full profit that they were expecting, and obviously not payment for any work that wasn't completed. All that needs to happen for this to occur is for the agency to determine that it's in the best interest of the government. Then they can effectuate the termination for convenience clause, and boop, that's it. The contract is over, either in full or in part. So we had a case where the prime contractor was terminated for convenience because the government exercised their right. It wasn't in the government's best interest anymore. They terminated the prime contract for convenience. But unfortunately, the prime contractor had not slowed down or otherwise accounted for termination for convenience in the subcontract. It's not one of those mandatory clauses. It is, of course, based on what we're going to talk about right now, suggested or recommended, I should say. So in this instance, prime contractor was T for C. Nothing in the subcontract that allows them to turn around and terminate their subs. To do so was actually a breach of contract. So the sub basically said, look, you entered into a contract with me for X dollars. That's great that the government's not going to pay you anymore, but you don't have a right to terminate me. So if you're not going to pay me and you're not going to let me do this work, you still owe me the money. That's not a great position to be in as a prime contractor, where the government has terminated your contract. You don't have any money that's coming in, but the subcontractor still is demanding to be paid. That's not a place that you want to be in. So what's the takeaway lessons for primes? Always want to avoid battling on two fronts or being stuck in the middle. Always want to carefully study your contract and know all the possible scenarios. If the government's got a right to terminate you for convenience, you're going to want to have a right to terminate your subcontractor for convenience, not just for default. You can find as a prime contractor that your rights and obligations might be dramatically different than what would be under standard boilerplate subcontract clauses. So you don't want to necessarily just go and use one of those form contracts you find on the internet, or a contract that you use for private contracts or state or local government contracts, etc. You really want to make sure you understand the clauses that are coming out of the FAR that are in your prime federal contract, and that you're accounting for them in your subcontract, and not just using boilerplate clauses that might leave you stranded like this contractor was. And also, going back to the theme that I kind of established at the very beginning, understanding the other party. When you are a sub, terminations for convenience are going to be in your prime contractor's prime contractor's contract. They're not going to have a lot of wiggle room. If you say, no, I don't want any termination for convenience clause in my subcontract, they're going to say, yeah, I'm sorry, there's no way I'm agreeing that I could be terminated for convenience, and I don't have the ability to do that to my subs. So that's not something that you're going to have a lot of wiggle room on. However, what you might be able to negotiate is, fine, you're worried about if you get terminated for convenience, being able to terminate me for convenience. So I'll agree to a clause that says if the prime contractor is terminated by the government for convenience, the prime contractor can terminate the subcontractor for convenience. But I'm not going to agree to a blanket termination for convenience clause where even if you're A-okay with the government, you can terminate my contract at any time. That might be an area where you have wiggle room. Again, even though it's important to understand this from a prime contractor's point of view, from a subcontractor's point of view, understanding that position and understanding what the prime might be scared of will let you know the boundaries within which you might be able to negotiate and might be able to gain a little bit of ground. The takeaway lesson for primes, from this example, protect yourself. If you have an obligation that implicates the sub, slow it down. If a sub could impact your ability to fulfill a responsibility or perform for the government, or cause an issue with deficient performance, account for that in your subcontract. Make sure that the subcontractor is accountable to you, at least to the same extent you're accountable to the government. Make sure that your rights vis-a-vis the sub mirror the government's rights vis-a-vis you. The primary objective as a prime contractor should always be to make sure that the obligations of the subcontractor mirror the obligations that you have to the government, and to make sure that the subcontractor is bound by the same procedures that you need to go through. All right, so that's been a lot talking about primes. And again, like I said, that also is helpful to subs because you can understand where the other party's coming from and understand where you may be able to negotiate. But let's talk a little bit more about subs in general. The biggest thing that we see, the biggest mistake that subcontractors make is agreeing to a non-specific catch-all type flowdown clause. Clauses like, the subcontractor shall assume to the contractor all obligations and responsibility that the contractor has assumed towards the owner. or the subcontractor shall assume to the contractor all obligations set forth in the prime contract, or all relevant and applicable provisions, et cetera, a bunch of legalese. Now, what's the problem with that? That seems kind of consistent with the advice that I've been giving to prime contractors, right? Remember that advice being always make sure that you have the subs promise that they are obligated to you to the same extent that you are obligated to the government. And that's true. That's, as a conceptual matter, what the prime wants to do. But for both the prime and the sub's best interest, if you're a subcontractor, especially if you're a subcontractor that doesn't have a lot of experience with the FAR or with the federal government, promising that you'll be obligated to your prime to the same extent they're obligated to the government, do you really know what you just promised? Do you know anything about the FAR clauses that the prime contractor is bound by? Therefore, do you know anything about what that means in terms of how the prime contractor is obligated to the federal government, or what procedures they need to follow? You just agreed, yeah, I'll do the same for you that you're doing for the government, but you don't know what the prime has to do for the government. Subcontractors need to understand their specific obligations and responsibilities, their specific scope of work, the specific compliance requirements, the specific notice provisions. Otherwise, you've got a situation where you're risking default, notice failures, and all the things that you're hoping to avoid in the first place. Vague catch-all clauses do not put subcontractors on notice of their obligations, and that is a huge problem for subcontractors because they have no idea what they just agreed to. But as we're going to see in a second, it is also a problem for prime contractors, or it can be. So the changes clause. A little bit of background, one of the most important clauses in government contracting. There's a couple different versions depending on what type of contract you're dealing with, but all government contracts are going to have some version of the changes clause. The example we're working with today is 52243-4B, and what that says is any other written or oral order. In other words, if the government gives direction, instruction, interpretation, or determination from a contracting officer that causes a change, shall be treated as a change order. So in other words, yes, if you get a mod, if the prime contractor gets an actual written mod on a federal government contract during performance, that's obviously a change to the contract. But what if you don't get a written mod, but you get the contracting officer directing you to perform work that's maybe outside the scope of the contract, or it's a little bit different than the way the contract says it should be done, means and methods-wise, or they're interpreting a clause in a way that's different from the way that you interpreted it when you were submitted your proposal or your bid, that's going to be treated as a change for purposes of the change order clause. And what that means is that the contractor needs to give the contracting officer written notice stating, hey, here's the date, these are the circumstances that just arose, this is the contracting officer order that I just got. I don't think that's within the scope of the contract. I think that's a change under 52243B, and I am giving you notice of that. That notice is what protects your right to get money later. So if there's a change to the contract, the FAR says, hey, you can go request an equitable adjustment of the contract to get more money to account for whatever additional costs you had to incur to kind of effectuate that change. But as you can see here in the second bullet point, you're not going to get that adjustment in price. You're not going to get that extra money if you didn't give the written notice that was required, the written notice we just talked about. Similarly, differing site conditions clause, 52236-2A. You shall, as a prime contractor, promptly and before conditions are disturbed, and I guess for those of you who aren't aware, differing site conditions, there's two different kinds. It could be when you arrive on site and the conditions on site are materially different from that were represented in the contract, or you can have a type 2 differing site condition, which is when you arrive on site and it's not that there was any affirmative representation in the contract, but it's just that the situation is so far out of the norm or what would normally be expected that it materially differs from that, what would normally be expected, or what's normally the situation in similar or analogous type jobs. So if you encounter that, the FAR clause basically says, hey, once again, that's going to be something that was not anticipated. You bid on the contract expecting X, and you get there, and it's Y. Y is materially different than X. Maybe you have to incur additional costs because you're dealing with Y instead of X when you thought you were going to be dealing with X. But like the changes clause, you're not going to be able to request, an adjustment of that contract, or you're not going to get an adjustment of your contract or additional money unless you've given the written notice that it talks about, in A. Give written notice before conditions are disturbed of the latent physical conditions of the site which differ materially from those indicated in the contract, or the unknown physical conditions at the site of an unusual nature which differ materially from those usually encountered, etc. So what's the bottom baseline coming out of both of these things? Notice under the FAR is critical to preserving claim rights. So if you are a prime or if you're a sub and something changes on the job, or you encounter a differing site condition and there's, additional costs that are going to be incurred by the sub and by the prime, or additional time that's going to be, required to perform the work because of a change or because of a differing site condition, the FAR accounts for that. They say, yeah, and in that situation, obviously the government should be paying the contractor more, should be giving more time to the contractor to perform, but only if they give proper notice. So notice is critical. So in the example case, we had a prime contractor that used a vague catch-all flow-down clause. Again, one of those, hereby, the sub hereby agrees to be bound to the prime to the same extent the prime is bound to the government. But subcontractor was incredibly unsophisticated, hadn't done any work for the federal government, didn't understand FAR clauses, hadn't seen a copy of the prime contract, really didn't know what they just agreed to, had no idea about the notice requirements, had no idea about how strict the notice requirements were, had no idea that claim rights kind of depended on fulfilling those notice requirements, which meant that there were changes on the project, there were differing site conditions on the project, and the subcontractor failed to give proper notice to the prime. Because the prime didn't know in a timely manner, the prime didn't give proper notice to the government. That ultimately meant that the government fought against paying the subcontractor's pass-through claim and the prime's claim. And we're going to talk about what that means in just a second, but for your purposes right now, basically the government said, we didn't get notice, we're not adjusting the contract at all. You don't get extra days, you don't get extra dollars, and sorry guys, you should have told us if this was happening. Your rights are predicated on giving proper notice. So that hurt the sub, but it also hurt the prime because the prime had damages that stemmed out of those differing site conditions and those changes as well because it delayed the overall project. So takeaway lessons for subs: do not agree to those vague flow-down clauses that are catch-alls with no specific language. Make sure you understand the obligations and responsibilities that you're agreeing to, and make sure that you understand the specifics. And that includes not only your obligations, but the procedures by which you need to go about kind of, fulfilling those obligations. Another key point, if there's a reference to the prime contract documents, get them. If it says that they're incorporating the prime contract by reference, get a copy of the prime contract. You want to know what you're agreeing to. And if it's classified, or if there's certain things that you don't have access to, or the prime contractor won't agree to give you a copy of their contract, then you need to rework the language to make sure that it works. Never agree to a catch-all flow-down clause if you can help it. Obviously, that's better than just a vague incorporation of the prime contract, but better off if you have specific clauses that outline each of the specific obligations and procedures you have. At the same time, we're talking mostly about this being a lesson for subs, but it's a lesson for primes as well. Remember, always understand the other party. If the sub isn't going to understand their obligations, you're not pulling the wool over their eyes or getting one over on them or, winning by hiding it from them. Their failure to do what they're supposed to do is going to get you in trouble, or could, very likely get you in trouble and cause you problems as well. It's not only going to be the sub that's harmed by their ignorance or their misunderstanding of their obligations. So subcontractor primary objectives: know what your obligations are, know what contractual procedures you must comply with, avoid assuming liability for compliance with clauses that are not mandatory. Again, understand where the party is coming from. If they're mandatory and they need to flow them down, the prime's not going to wiggle. Know which clauses are mandatory, know which ones aren't. Argue back if they're not mandatory. You don't want risks shifted to you if they don't have to be. Understand, the confines within which the prime has room to wiggle and where they don't, so that you can negotiate on the room or on the pieces where they do have wiggle room. You do not want to avoid liability or agree to clauses that aren't mandatory, that shift risks to you, or that aren't applicable to your scope of subcontract work. So generally speaking, when you're thinking about flow-down clauses, what what do you want to be thinking about when you're kind of going through a checklist? All right, what do I need to think about incorporating? What are some important issues? Obviously, what are the mandatory clauses? Go through those. Make sure that you slowed those down. Just talked about notice provisions, the importance of those. Make sure that if you've got certain things that might come up and you have to provide notice to the government, make sure that the subcontractor needs to provide notice to you. And as a best practice hint, if you have to provide notice to the government in 10 days, probably don't make it that the subcontractor has to provide notice to you within 10 days. You want to leave yourself some more time. Maybe they need to give you notice in 7 days or 8 days so that you can give notice to the government. Terminations we talked about. Terminations for convenience and terminations for default. You're going to want to make sure that if you've got a termination for convenience clause, you're able to turn around and do the same to the subcontractors. Also, if you've got an issue where you're defaulted by the government, you want to be able to, default subcontractor. Delays, liquidated damages. If the subcontractor causes delays, how are you going to deal with that? If the subcontractor causes delays and you get assessed liquidated damages, how are you going to deal with that? As a prime contractor, if you're a sub, how much responsibility do you want to take here? You don't want to get in a battle for all of the liquidated damages that are assessed against the prime. That's probably something you want to fight back against. Suspensions. There's also a possibility that the government could suspend work on a project. What happens while that is going on? You might have to sit on the job ready to go and not demobilize or not, ramp down your labor or not shut down the access to the computer systems. What's the sub going to do during that time? Changes, we just talked about, but also another aspect of changes is not just notice, but, if there's a change to the contract and the government orders you to do something as a prime and you don't agree with it, you think the government's wrong, you think you're ultimately going to have a claim against them, but you have to go forward with that work. So you want to make sure that if it's within the sub scope of work, you can force it down on them and say, look, you might be disputing this with me, but in the meantime, until the dispute is worked out, you've got to do the work. Dispute and dispute resolution, which we're going to talk about in more depth in just a little bit. Those are kind of some of the major things you want to talk about. Obviously, cost and pricing is another thing, options, exercise. Other things that aren't necessarily substantive but are kind of tangential, labor and employment issues, ethics requirements, other compliance concerns. Those kind of all fall under the category of, especially depending on, for those of you out there that do business with the DoD, all the cybersecurity stuff that's going on right now, all of the new cybersecurity requirements, what do you need to slow down? What do you need to make sure that your subcontractors are doing in terms of, not just executing the contract itself, but kind of the other obligations they have in terms of affirmative action or ethics plans or Buy American, compliance or cybersecurity requirements, et cetera. You're going to want to make sure that you put those into your subcontract as well. Maybe they're flowdown clauses, maybe they're risk shifting provisions, maybe they're just things that you want to make sure that your subcontractors are complying with to make sure that your own compliance concerns, kick in. And finally, IP issues. Do you have anything where you're going to be sharing as part of the subcontract proprietary information, confidential information, pricing information? How are you going to protect that? Do you need an NDA or do you need some sort of, agreement in place to protect IP rights? A quick note on limitations in subcontracting before we move on to the very important piece of dealing with claims and disputes between subs and primes on federal jobs. If you are dealing with a subcontract on a set-aside, and by that I mean a contract that was not open for full and fair competition, but rather not an unrestricted procurement, but a set-aside procurement where only 8A or only small businesses or only women-owned businesses could compete, et cetera. 13 CFR 125.6 is something you need to be aware of. And what that says is when you're talking about any small business set-aside over the simplified acquisition threshold, so any small business set-aside that's over $100,000 or any 8A, SDVOSB, SBC, in other words, SDVOSB, hub zone or WSB, EDWSB set-aside contract, you need to worry about complying with this clause. Doesn't apply to unrestricted procurements, doesn't apply to really small business set-asides, but anything that fits within one of these two buckets, this is going to apply. And what it says is you can't turn around and subcontract out a lot, too much, I should say, of your contract. The reason for this is these small business programs were designed because the government thought, hey, certain small businesses should get a leg up, to get certain advantages when competing for government contracts, we're going to, have these aspirational goals where a certain percentage of our contracting will always go to small businesses. What they don't want is a situation where a small business gets a set-aside contract, and then that small business turns around and subcontracts out 99% of it to a big Goliath company. Because what does that mean? It means, great, the small business is getting 2% of the dollars that were set aside for small business, but 98% of that contract is, the revenue is actually flowing right through the small business and going to a large company. That kind of defeats the purpose of the small business program. So what they did is they put in place, a FAR clause and also this small business regulation that says, hey, look, you're limited in how much you can subcontract. If you're talking about a contract for services, except for construction, which we'll talk about in the next slide, you can't pay more than 50% of the amount paid by the government to you to firms that are not similarly situated, and we're going to talk about what that means in just a second. Similarly, if you're a supplier or, it's a contract for supply or products other than a non-manufacturer, which is a separate rule, again, you've got that 50% limitation. You can't subcontract out more than 50% unless you're doing it to a firm that's similarly situated. And what that means is, are they also the same type of small business? Is this an 8A set-aside and you're an 8A and you're subcontracting to another 8A? All right, that's not going to count towards that cap because they are a similarly situated entity. If it's an SDVOSB contract and you are trying to subcontract to another SDVOSB, they are a similarly situated entity. They're not going to count towards your cap. But things to keep in mind is if they turn around and subcontract, that can mess that up. It could go back into the calculation for your cap. If you've got different NAICS codes on your subcontracts than you do on the prime contract, that can kind of change this analysis. So the similarly situated entity is a little bit more complex than it seems on first blush. If you've got questions about that, you really should contact a legal professional to make sure that you are compliant. So that's services or supplies or products contract. General construction can't subcontract out more than 85%, again, unless they're similarly situated entities. Specialty trade, 75%. Note for both of these that the cost of materials are excluded and not considered to be subcontract. Also, we're not going to get into teaming and joint venture and mentor-protege today. That's, a different topic. But for those of you who, have heard the mentor-protege split of the 40% work of the protege, that is an additional requirement separate and apart from this. So keep in mind that if you're dealing with a mentor-protege JV, you've got to comply with this regulation, and you've got to comply with the regulation that says that the protege concern has to perform 40% of the work that is done by the JV. The JV itself needs to perform the requisite amount of work under this regulation. So again, it can get a little bit complicated. If you have questions, consult, your PTAC, your business center, or a legal professional. As we talked about, similarly situated entities exception has some complications to it, so you should be aware of those, and if you have questions, seek guidance. All right, so moving on, we're now going to move into the section where we're talking about the disputes that can arise between a subcontractor and an owner and a subcontractor and the prime itself on federal government contracts, because this is obviously a big piece of what you need to be looking out for, planning ahead, trying to avoid, et cetera, in your subcontract drafting. So the first thing that you need to be aware of is that kind of unlike in other areas, because of sovereign immunity, which is a general rule that, you can't sue the federal government, subcontractors don't have the right to assert any sort of claim directly against the government. So you've got sovereign immunity, which is a general rule that says, hey, people can't sue the federal government. There are obviously exceptions to that. The Tucker Act and the Contract Disputes Act, they make exceptions and they say, all right, so generally speaking, you can't sue the federal government, but if you have a contract with the federal government, then you can sue them in compliance with the FAR and in compliance with the Contract Disputes Act. But that exception only covers if you have a contract. In other words, the prime contractor has a contract with the government. The subcontractor doesn't have a contract with the government. They have a contract with the prime. So there's no what we call privity of contracts between the subcontractor and the United States, the federal government. So that means they are not subject to that Tucker Act CDA exception. which means that in order to file a claim where the sub is saying, hey, I don't think my prime did anything wrong, I think the government owes us this money. I think this is something that the government is obligated to do or liable for did wrong and needs to pay us back for. If that situation arises, the sub has to rely on its prime to sponsor or pass through its claim, which is why you hear these claims called pass-through claims. It's when the subcontractor says, going back to the example I used before, there was a change on this contract. You were supposed to construct a building. I was supposed to do the asbestos abatement. We got there. There was a ton more asbestos. That's a change. That's a differing site condition. I gave the proper notice. The government owes me more money because I had to spend 3 times what I thought I was going to spend doing the asbestos abatement portion of the job. And the prime goes, yes, I agree. On top of that, you took 2 months longer, which meant that I was delayed. All of my other subs were delayed. That means I have money that I'm entitled to as well. I'm going to file my claim for the delay that I suffered, and I'm going to pass through or sponsor your claim for the direct costs for the additional scope of work, etc. That's just one example. Those claims, the pass-through claims, like any prime contractor claims, are ruled by the Contract Disputes Act and the disputes provision of the FAR. The Contract Disputes Act and the FAR provides that basically you have to exhaust your administrative remedies first. So remember, going back to my first slide, federal contracting is a unique space. It's not like private contracting. It's not like local government or state government contracting or municipality government contracting. You can't just file a breach of contract claim or a lien or anything like that. You need to go to the contracting officer, file a claim, wait for them to respond, wait for them to deny it, wait for them to wait so long that it's considered a deemed denial, one of those scenarios, and then you can go to an actual, adjudicatory body like the Court of Federal Claims or one of the boards of contract appeals. People who are used to dealing with, private contracts, they're used to, okay, something went wrong between me and my prime or me and my sub. I sent a demand letter. I waited 30 days. They didn't get back to me. I filed a complaint in state court or maybe district court, federal district court. You can't do that in the federal government context. You have to try first to resolve it with the agency before you go outside the agency with a complaint to a court or a board of contract appeals. That, prime contractors who do business with the federal government are aware of that. Subcontractors, a lot of times, are not. Again, that's one of those things where the more specificity you have in your contract and the more you talk about the disputes procedures, the more the subcontractor is going to be on the same page and understand the disputes procedures, even if they're not familiar or haven't dealt with the federal government before. And the reason that's important is that the CDA, it can be a long, complicated legal process. You've got to get a claim together. You've got to certify the claim. You've got to wait at least 60 days. Usually it's a lot longer than that to get an answer from the government. And then and only then can you start the court process. That puts you months behind where you would normally be in a normal private action where you go straight to the court with a complaint. Maybe that's fine for the prime to continue to, have that IOU on their books. But a lot of times when small businesses or subcontractors or, subcontractors in general that are just smaller, they don't have the money to just kind of sit and wait for a claim to be paid. So that can sometimes cause conflict. The prime is going to litigate because, again, they're the ones with privity. The sub is going to support. And unsurprisingly, this can be a huge source of prime-sub conflict, even though it's all about what went wrong at the federal government level and going after the federal government. It can cause a lot of tension between the prime and the sub, and it's one of the things that's most important to account for in a subcontract. You might be wondering why this is such a huge source of conflict, and I agree it doesn't always make sense because it seems like, well, if you're blaming the government, you're not saying that the other party is responsible. The sub's not saying the prime is responsible. The prime's not saying the sub's responsible. You agree that it's the federal government you have to go after. But it puts them at odds not necessarily by pointing fingers in terms of the blame for the substantive issue, but more in terms of the procedure and the timelines, like we just talked about. You've got a complicated procedure, and it's a long process. So remember the approach. You want to understand each other to try to figure out the best way to deal with it in your subcontract. What's the prime scared of? The prime is scared of fighting a battle on two fronts. In other words, they're scared of the subcontractor saying, well, fine, this is taking too long to go after the government. I'm just going to sue you. And meanwhile, they're also fighting upstream the government with the pass-through claim trying to get the money. They're scared of being stuck in the middle. You know, the government comes back and says, hey, you know, you did this wrong. We're going to assess LDs against you. And meanwhile, the sub is saying, well, the whole reason we were late is because of that differing site condition or because of that change. And the prime is stuck in the middle trying to figure out how to kind of, you know, balance those two things. The other big thing that can come up is, as I said, you're under the CDA when you file a pass-through claim. CDA requires that claims over $100,000 are certified. And because it's the prime that's passing through the claim, it's the prime that needs to give that certification. If their subcontractor gives them a bunch of cost documents or, you know, a bunch of information about costs or damages they incurred and that information is fraudulent, well, even though the prime contractor wasn't the one committing fraud, they just certified something fraudulent. That could get them in trouble in terms of, you know, forfeiting not only the subcontractor's claim, but if they had any claim that they kind of sent up at the same time. It can also subject them to False Claims Act and other fraud statutes and criminal proceedings, et cetera. You obviously don't ever want to be vouching for something that is somebody else's. It's always going to kind of put you at a loss when you've got to certify that someone else is being honest. So you're going to see a lot of times prime contractors hesitant or reluctant to pass through claims unless they can agree that the subcontractor certifies to them that everything is accurate, and unless there's some sort of remedy if the subcontractor certification ends up being fraudulent, because it is a big risk for the prime contractor to take to put their name on that certification. On the other hand, what's the subcontractor scared of? Well, like I said, they have a lack of remedies. They can't go after the government themselves. They have to rely on the prime to sponsor them. So if the prime just says, yeah, no, I'm sorry, I don't feel like that. I'm not going to sponsor your claim. I'd rather go to the ball game today. What's the subcontractor going to do? They can't go after the government themselves. They're kind of left without any recourse. They can't recover for their damages. So the biggest fear that subcontractors have is, all right, how am I going to, write the subcontractor? What kind of terms in a subcontract can I agree to that are going to leave me with a remedy if the prime contractor doesn't do what they're supposed to in terms of passing through a claim? And before we move on to the last slide, I'll tell you there was a case a couple of years ago called Appeal of Bingham, and it was the Armed Services Board of Contract Appeals case, and it was a perfect example of how these issues come up. The subcontractor had put together a claim. They thought that it was great. The prime contractor didn't agree. The prime contractor refused to pass it through, and the subcontractor tried to sue the federal government under in the Armed Services before the Armed Services Board of Contract Appeals. And the Armed Services Board of Contract Appeals said, look, we're really sorry, guys, but, I'm sorry that your prime contractor refused to pass this through, but you don't have privity of contract with the government. Your only recourse is to try to go after your prime contractor for their failure to, their failure and their refusal to pass through your legitimate claim. We can't do anything, case dismissed. So again, it shows that, even when your prime contractor says, yeah, no, I don't really feel like helping with your pass-through claim. I'm not going to sponsor your claim. I don't feel like certifying that. I don't believe you, or I don't like you, or, I don't feel like cooperating with you, or I just don't have the time. Whatever their reason, you're limited. That doesn't mean, okay, fine, I'm just going to try it myself. You can't try it yourself. You are prohibited by law. There's a sovereign immunity bar. It's jurisdictional. You're not going to get through it. Your only recourse in that sense then is to go after the prime. So how do you go after the prime? You make sure you have something in your subcontract that says that they have an obligation to pass through your claim. You're going to want to draft your subcontract to include something like that. You're usually going to see in well-drafted subcontracts something that says, all right, from the, to assuage the sub's fears, as long as I do A, B, and C, you agree to sponsor my claim, you agree to pass it through, you agree to, get me around that bar of privity of contract. And to assuage the prime's concerns, it's all right, as long as you do A, B, and C, I will do that. But A, B, and C are going to be, you prepare a really good claim, you certify it, and you indemnify me for any damages for false certification or, something along those lines. That way the subcontractor is getting what they want. If the prime refuses to pass through their claim, they can sue the prime for breach of contract. They can't go after the government, but at least they have recourse against the prime. And the prime can say, all right, I have no problem passing through your claim, and if everything goes well, everything goes well. But if you turn out to be a big dirty liar and you gave me a bunch of false information, I'm not going to be the one that's ultimately hurt. I can come back after you for those costs. Other things you're usually going to see is that the sub will help in preparing the claim. They obviously will cooperate. Maybe they'll help fund the legal bills, obviously, since it's on the sub's behalf. And you're also going to address those FCA fraud issues. Keys to good subcontracts are disputes clauses that differentiate between a sub's disputes against the owner, which is the process that we just talked about, those pass-through claims, and disputes that are against the primes themselves. Breach of contract, based on, for example, failure to pass through a claim. The disputes clause, you're going to want a disputes clause that explicitly refers to the CDA, the Contract Disputes Act, remedies and process, and demands patience. It's going to put the subcontractor on notice of what they need to be prepared for in terms of wait time and procedural complexity. And also the disputes clause that provides for penalties for fraudulent certification. And depending on state law that you're in and how you want to handle things, you might want to consider arbitration, etc. So here's a sample clause that you're going to see. Any dispute resolution procedure in the prime contract shall be deemed incorporated in this agreement. Any claims or disputes not covered by the dispute resolution procedure shall be submitted to arbitration in accordance with the construction industry rules, etc., etc. This is what we commonly see in subcontracts with boilerplate language. It's an arbitration clause applicable to disputes between the prime and the sub that does not involve the government, and a requirement that all disputes that are involving the government, that are disputes against the federal agency, saying the federal agency is liable or should be paying the damages, etc., that those need to be passed through the government for resolution under the disputes process we just discussed. However, there's two principal problems with this clause. Number one, it doesn't adequately incorporate the disputes procedure from the prime contract. So that first 14.1, it's not specific enough. Number one, it's not specific enough for legal purposes. I'm going to talk about it in just a second. Number two, it's not specific enough to put the sub on notice of what that means, what the sub, what the procedures are going to be, how long they might have to wait, etc. It also poses a problem with regard to the Miller Act, which we're going to talk about at the end of the presentation. Second, the second biggest problem with this clause is it doesn't provide a mechanism to decide whether the dispute is between the sub and the prime or the sub and the government. That is something that comes up a lot. If everyone's on the same page, okay, we blame the government for this. Or, okay, this is a dispute between the prime and the sub. It has nothing to do with the government. Great. But a lot of times you'll see something comes up in a fuzzy area, and the sub, especially if they're impatient with waiting for the government to respond or getting some sort of payment from the government, all of a sudden it starts migrating. And maybe this wasn't that that the government did anything wrong. Maybe this was the prime contractor after all. The subcontractor often is going to try to argue that the dispute does not involve the government, and therefore we should be going to that second piece, that arbitration piece, and not dealing with the long, drawn-out Contract Disputes Act claim. The courts are usually going to send the parties to arbitration in that case. They're going to say that they need to figure out if it's arbitrable. The prime could be forced to go through the arbitration process before ever getting to pass the claim through. That can make it a lot more expensive for the prime. So we've had numerous clients who have ended up paying off subs to get out of arbitration, and then they have to go on to litigate the government to recoup their losses. That's exactly what primes are trying to avoid, that being caught in the middle. So what's the solution? Either omit an arbitration clause entirely or spell out in unequivocal terms that the prime has the sole right to determine whether the dispute involves the government or not. Obviously, that's from a prime contractor's point of view. You're going to want to limit yourself or limit the subcontractor from damaging you. If you're a subcontractor, you're probably not going to want to agree that the prime is the one that dictates which one of the disputes clauses is applicable. So that's one of those things that often falls through the cracks. People, know best practices. All right, great. I have one clause that applies to, prime sub and one clause that applies to pass-through claims, but who's the arbiter of, which goes under which clause is oftentimes ignored. So, best practices, disputes clause from the prime contract, slow that down in full text, verbatim. It's going to give much more specificity. An additional clause should be included requiring the subcontractor to proceed with work. Remember that prosecution of work while you're doing, continuation of work, prosecution of work while you're disputing whether or not they have to do the work. because that's what the government's going to require of the prime. That's what the prime is going to want to require of the sub. You're also going to want to do what we just said, have two separate clauses, and then also decide who's the arbiter of which clause that you go under. One word real quickly on liquidating agreements. These are agreements that are not in the subcontract itself, but they're a separate agreement that subs and primes will put together once they agree to do a pass-through claim. So the subs put together their claim, they've certified it, they've passed it up to the prime signs off on it, the prime has certified it, passed it up to the government. Now it's all about how that claim itself is litigated. And it's going to basically be right about how the pass-through claim itself, who's going to be responsible for what, who's going to pay what portion of the lawyer's fees, who's got veto power to accept or reject a settlement offer. If you accept a settlement offer, let's say that the claim was $5 million, 2.9 of that was the subcontractor's claim, and the rest was a prime contractor's claim. Let's say they settle it for 4. Who's going to take the hit? You wanted 5, you're only getting 4. Does one party get paid their total fees first, or do you break it up on a percentage basis, et cetera? Those are all things that you need to think about. Also, who's going to have the, who gets to decide if they're appealing it if you don't win. All about, what happens in this litigation itself now that we've got a pass-through claim, now that we've got this shared baby that we're passing up through to the government to try to get some money. How are we going to apportion responsibility, costs, and obligations? Best contracts for disputes clauses, again, set forth a method to determine if the subcontractor's claim is a claim against the government, and you're also going to want to set forth explicitly what dispute resolution procedures must be exhausted before the subcontractor can demand arbitration, and this is from a prime contractor's point of view. All right, we already talked about certification, so I'm going to flip that slide. All right, so moving on from the pass-through claims against the government to the actual claims between subcontractors and primes. Again, most of these come up, well, I shouldn't say most, but a large portion of, in the federal government context, claims between the primes and the subs really do relate to pass-through claims that either haven't been properly certified by the sub, or the prime doesn't want to pass through because they think the sub's done something wrong, or the sub is, trying to push it through and is mad that the prime won't do so. So if the prime refuses to honor a subcontract, the subcontractor can bring suit against the prime in the appropriate U.S. District Court, proceed to arbitration if authorized. Again, we just talked about some of the stuff that goes into arbitration clauses, or possibly submit a claim to the prime's surety, which is a Miller Act claim, and we'll talk about in just a second. It's important to keep in mind here, though, even though there's access to the federal courts for these suits, it's not going to be federal law that governs the subcontract. It's going to be state law. So usually you've got a contract between a prime and a sub, and it says, usually in the miscellaneous section of the subcontract at the end, governing law. And it says that this will be, decided according to the laws of Pennsylvania or Arkansas or Arizona or Alaska or Virginia, whatever the case may be. This can cause a lot of confusion for the uninitiated practitioner or for, unsophisticated contractors. For example, you might have a contract that's governed by state law, but any arbitration clause in the contract is going to be enforceable under the Federal Arbitration Act and subject to the precedent established in that circuit. So there can be a wide divergence amongst the circuits in how the Federal Arbitration Act is enforced. So one of the things that you're going to want to talk about with a lawyer when drafting your subcontract, have some idea of, your state law or which state law, the other party is asking to apply. Have some idea of, your circuit law on the Federal Arbitration Act and, have that inform how you set up the arbitration procedures if you want any arbitration procedures in the contract. Other ADR issues, mandatory mediation, arbitrability, location, and attorney's fees. Mandatory mediation is usually a good idea. Waiver of arbitrability determinations, is something that you need to kind of think your way through based on everything we just talked about with FAA and state law and FAA circuit cases. And usually the location is going to be the project site, so that's going to determine some aspect of which law is used. Also, attorney's fees. You'll see sometimes something called a prevailing party provision. that will sometimes, and actually before I move on to that, for those of you who do work in the construction field in particular, you might see there are, no damages for delays or, certain clauses like that are enforceable in certain states and not others. You're always going to want to make sure the contract might sound really good to you, but it might say that it's under, X state's law, and that's the state where the other person is based, and they know that even though they put a certain, clause in the contract, it's not enforceable. So you're always going to want to make sure you do research on, state-specific clauses that might not be enforceable. So along with that, prevailing party provisions, that usually is an attorney fee provision that basically says, look, when it all comes down and whoever wins at the end, they've got to pay everyone's attorney's fees. That sounds great if you know that every argument you're going to get into is a slam dunk and there's no chance you're ever going to lose. But let's say something comes up and you're like, our argument on that isn't super strong, but we think we should try it anyway because it's a $2 million issue. So you try it anyway and your argument wasn't that strong and it doesn't go your way, and now not only do you have to pay your lawyer's fees, but you have to pay the other side's lawyer's fees as well. Prevailing party provisions can be, a lot more dramatic shift, and they can ultimately end up making you down the line think, a lot more carefully about whether you want to have any fight at all or any dispute. They lead to a lot quicker settlements, but they also can lead because of that to nuisance suits and whatnot. So make sure you understand what a prevailing party does or any sort of attorney fee shifting provision does, and really talk about with your lawyer what you think that means for you and how it could negatively affect you in the future. Other issues in sub versus prime litigation, damages for delay. I just said, that might be a clause that is or is not enforceable. Pay if paid, pay when paid, same thing. Exhaustion of administrative remedies, and jurisdiction. It's not uncommon to have boilerplate clauses attempting to limit the prime's payment obligations to a when or if paid by the government. These clauses are generally, again, going to be interpreted under state law. They may be enforceable certain places. They may not be enforceable other places. It's going to depend on what state you're in and what state law you've selected to govern your contract. That's going to be something that you really want to make sure to figure out before you agree what state law requirements are going to govern the contract. Important to figure out what you can enforce, what state law requirements are, what they say about prompt payment, and then make sure that your subcontract is consistent with those requirements in a way that, benefits you. Typically, a boilerplate clause requiring exhaustion of administrative remedies against the prime is not going to be effective to prevent the sub from pursuing litigation. You've got to be a lot more specific. We previously discussed ADR, alternative dispute resolution, like arbitration or mediation. But just to reiterate, arbitration is usually going to be enforceable, and mandatory mediation provisions are usually going to be enforceable as well. You should always include a provision specifically agreeing to Contract Disputes Act jurisdiction. All right, so finally, we're almost out of time, and I want to leave some time for questions. But real quick, other things that you should be aware of if you are a subcontractor to a prime contractor on a federal government job. Particularly in the construction context. Again, federal government is unique, whereas if you're on certain other types of projects and the prime stops paying you, you might have lien rights. You might be able to lien the property or do something that goes further upstream, kind of jumps over the prime's head and tries to, get you in a place where you've got a little bit of leverage. There are no liens against the federal government. Again, sovereign immunity type argument, the federal government's got certain protections. They're not going to allow federal land to be liened. So where does that leave you as a subcontractor if your prime contractor just says, yeah, no, I'm not paying you? Or what if your subcontractor goes broke? Your prime contractor goes broke, or, we've seen certain federal government contracts where you're dealing with a prime contractor that's outside of the U.S. and you can't sue them here. What do? Well, there are Miller Act claims. The Miller Act is something that was put in place to protect subcontractors and suppliers on government contracts, and it basically says that if you've got a job for public work, which is going to include construction of public buildings, et cetera, then you have a remedy against the surety. Or rather, the law says that the prime contractor, has to enter into bond agreements with a surety. The purpose of that is to protect both the federal government and the subcontractor. So the Miller Act requires a performance bond and a payment bond. The performance bond says, hey, if I fail to perform, my surety is liable to the government to the costs the government needs to spend to finish the performance that I should have done. So that's performance bonding. That's not really relevant to what we're talking about today. The one that I'm talking about is payment bond, which basically says, hey, if I don't pay my subs, my surety is liable to my subs to pay them anything I should have paid them. That's the provision that protects the subcontractors, and that was put in place because there are no lien provisions. So if you are a subcontractor and your prime has just gone MIA, they're not paying you, you can try to not only go after them for breach of contract, but you can try to, and maybe you're in a situation where going after them for breach of contract is going to raise all sorts of issues and get you into that complicated mishmash that we just went through with the CDA and with arbitration and with mediation, et cetera. Maybe it's just easier to go after their surety. So with the Miller Act claim, you, if you're a first tier or a second tier contractor, you can go after the surety. You have to provide notice if you're a second tier subcontractor. You don't if you're a first tier. Miller Act claims are kind of outside the scope of today, so I'm just kind of briefly touching on them. If you have additional questions, feel free to reach out. But it's another remedy that you can use to go after and get some money in a subcontract situation if you're dealing with a construction project in particular. And it's another way to kind of force leverage because most prime contractors don't want their surety knowing that there's some sort of payment dispute. So a lot of times if someone's ignoring you, if you all of a sudden start threatening a surety claim or give notice to their surety, start threatening a Miller Act claim or give notice to their surety, you will see that maybe the wheels start moving a little bit quicker and they start taking you a little bit more seriously. So that's just another thing to keep in mind. All right, so with that, I will open it up to any questions. If you've got questions, you can put them in the chat box. If you don't have any questions right now, or if you, have questions that all of a sudden you think of 3 days from now or 3 weeks from now, please feel free to reach out. My contact information is on the screen, my phone number, my email, and also, again, on the first slide, you can follow me on Twitter or on LinkedIn, find out about other webinars like this that I'm doing on small business or government procurement issues, articles that I've written. You can follow along with our blog posts, etc. It doesn't look like any questions have come in. So with that, I guess I will, happy Friday. You guys get out 10 minutes early. Thank you, everybody, for joining. I hope you have a wonderful weekend. And don't forget to sign up for Part 4 of our webinar series. And look forward to seeing you there. Thanks a lot. Bye-bye.